The morning this case landed on my desk, it looked ordinary: a property dispute, a landscaping complaint, a disagreement between a homeowner and a developer. In court, those kinds of cases arrive every week. Most of them are arguments over money. Some are arguments over pride. A few are arguments over principles. But every now and then a file appears that reminds you why justice matters in the first place. When I looked at the paperwork, I saw two names. The first belonged to a powerful real estate developer whose company had spent years buying properties throughout the county. He was wealthy, connected, and accustomed to getting his way. His attorneys had submitted hundreds of pages of documents, surveys, permits, and technical reports. Everything was organized. Everything looked professional. The second name belonged to a 78-year-old widow named Margaret Collins. Her submission consisted of only a few photographs. That alone caught my attention. Powerful people often arrive with stacks of paperwork. Ordinary people arrive with the truth and hope someone will listen. When court began that morning, the developer walked in surrounded by lawyers, expensive suits, expensive watches, expensive confidence. They carried themselves like people who had already won. Margaret walked in alone. No lawyer, no assistant, no entourage. Just a small purse, a folder of photographs, and hands that trembled slightly with age. I have spent enough years on the bench to know that appearances can be misleading. Wealth does not automatically make someone right. Poverty does not automatically make someone wrong. But I also know arrogance when I see it. The developer barely looked at Margaret. To him, she seemed insignificant. That was his first mistake. As testimony began, his attorney confidently explained that construction crews had entered an adjacent area during a property expansion project. According to their argument, any damage that occurred was accidental, minimal, and legally permissible under local regulations. The words sounded impressive: accidental, minimal, permissible. Lawyers love words that make ugly actions sound harmless. Then it was Margaret's turn. She stood slowly. The courtroom became quiet. She wasn't dramatic. She wasn't angry. She simply looked tired. The kind of tiredness that doesn't come from lack of sleep, the kind that comes from loss. "My husband planted that garden," she said softly. Those 5 words changed the atmosphere of the room. Suddenly, this wasn't about landscaping. It wasn't about property lines. It wasn't about permits. It was about memory. She explained that 46 years earlier, shortly after buying their small home, she and her husband had started planting flowers together. Every section of the garden carried a story. A rose bush planted after the birth of their daughter. A cherry tree planted after their 20th wedding anniversary. A small stone pathway built by hand during one summer vacation when money was tight but happiness was plentiful. As she spoke, she wasn't describing plants. She was describing a life. Many people think gardens are just collections of flowers. They're wrong. Sometimes gardens are photo albums that happen to grow from the ground. The developer sat expressionless. Margaret continued. 3 years earlier, her husband had passed away. Every morning since then, she walked through that garden. Every evening before sunset, she sat beside the cherry tree they planted together. It was how she stayed connected to him. Then one Tuesday morning, she woke to the sound of machinery, bulldozers, trucks, construction crews. When she walked outside, workers were already tearing through part of her property. Flowers destroyed, shrubs uprooted, stone pathways broken, decades of memories reduced to piles of dirt. The courtroom remained silent. Nobody interrupted her. Nobody needed to, because everyone understood. The developer's attorney quickly objected. He argued that emotional testimony was irrelevant. He wanted to focus only on legal boundaries and permits. I understand why. Facts are easier to defend than feelings, but justice requires understanding both. I asked Margaret if she had photographs. She nodded. Then she handed them to the bailiff. The first photograph showed The garden years earlier, color everywhere, care everywhere, love everywhere. The second photograph showed the aftermath. Destroyed soil, broken stone, splintered wood. Silence filled the courtroom. Then something interesting happened. The developer looked away, only for a second, but I noticed. People often reveal more in 1 second than they do in an hour of testimony. I turned to the developer. Did you personally inspect the property before construction began? He answered confidently. My team handled that. A simple answer, but not a complete one. I asked again, did you personally inspect the property? No. Another short answer. I made a note. Then I asked whether he had ever spoken to Margaret before construction started. No. Had he warned her? No. Had he attempted to compensate her immediately afterward? No. Had he apologized? The courtroom became very quiet. No. That answer seemed to hang in the air because sometimes one word tells you everything. The developer continued explaining permits, surveys, and legal authority. He spoke for nearly 15 minutes. By the end, he had explained what his company was allowed to do, but he had not explained why they did it. There is a difference, a very important difference. The law determines what is permitted. Character determines what is chosen. As testimony continued, Margaret revealed something the developer's team clearly hadn't expected. She produced a handwritten journal. At first glance, it looked insignificant, an old notebook. Worn edges, faded pages. The developer's attorney almost laughed. Then Margaret explained what it was. For more than 30 years, her husband had documented every addition to the garden, every tree, every flower bed, every improvement, every anniversary planting, every family milestone. The notebook wasn't a gardening record. It was a history book. Suddenly, those destroyed flowers carried emotional value that no appraisal could accurately measure. The courtroom listened as she read several entries aloud. One entry described planting roses after surviving a difficult financial year. Another described rebuilding part of the garden after a storm. Another celebrated 25 years of marriage. You could hear people breathing. Nothing else. Even the attorney stopped taking notes. The developer shifted in his chair. For the first time that day, he appeared uncomfortable. Good. Discomfort is often the first step toward accountability. Then came the moment that changed everything. Margaret reached into her folder and produced a photograph nobody had seen before. The image showed construction workers standing near her property several days before demolition began. One worker was pointing directly toward the garden. Another appeared to be taking measurements. The timestamp was visible. The date was clear. The implication was obvious. Someone had seen the garden. Someone had recognized it. Someone knew it existed. That photograph raised a question nobody on the developer's side wanted to answer. If workers had identified the garden days earlier, why wasn't it protected? Why wasn't construction adjusted? Why wasn't the homeowner contacted? Why wasn't a solution found? The developer's attorney immediately objected. But objections cannot erase questions. And in my courtroom, unanswered questions matter very much. I leaned back in my chair and looked toward the developer. For the first time all morning, his confidence seemed smaller. Not gone, just smaller. The kind of confidence that starts cracking when reality enters the room, because this case was no longer about property damage. It was becoming a story about choices. Choices made by people who had power, choices made by people who believed nobody would challenge them, choices made by people who forgot that every line on a survey map belongs to someone's life. I closed the photograph folder carefully. Then I looked directly at the developer. The next question I was about to ask would determine the direction of the entire case. And judging by the expression on his face, he already knew it. I looked directly at the developer. Who made the final decision to proceed with construction after your team inspected the area? The question was simple. Simple questions are dangerous because they leave very little room to hide. The developer adjusted his tie. My project manager handled operational decisions. I nodded. So you're saying the responsibility belongs to your project manager? That's correct. His answer came quickly, too quickly. People who tell the truth usually remember. People looking for an escape route respond immediately. I turned toward the evidence table. Among the documents submitted earlier that morning was a chain of internal emails obtained during discovery. At first glance, they looked routine. Project schedules, site updates, budget discussions, the kind of corporate communication most people never read. But buried inside those emails was something interesting, very interesting. I picked up a printed page. Mr. Harrison, is this your email address? Yes. And did you send this message? He glanced at the page. Yes, I read aloud. The homeowner may complain, but delays will cost us more than replacing a few plants. Proceed as scheduled. The courtroom became silent. The developer immediately leaned forward. That statement is being taken out of context. I held up a hand. I didn't ask for context. I asked if you wrote it. His jaw tightened. Yes. Another short answer, another crack in the wall. A few moments earlier, he had attempted to place responsibility entirely on his project manager. Now the evidence showed he personally knew concerns existed before construction began. The difference mattered a great deal because accidents happen, negligence happens, but knowingly disregarding consequences is something entirely different. Margaret sat quietly at her table. She wasn't smiling, she wasn't celebrating, she simply listened. I think she understood something many people forget. Truth doesn't need applause. Truth only needs time. The developer's attorney immediately attempted damage control. He argued that the phrase "a few plants" referred to landscaping estimates, not the garden itself. A clever argument. Unfortunately for him, the next email existed. I lifted another page. This one had been sent by the site supervisor. It read, the elderly homeowner became upset after learning part of the memorial garden may be affected. Memorial garden, not landscaping, not vegetation, not decorative plants. Memorial garden, words matter, especially when written before a lawsuit begins. The developer looked down. The attorney stopped speaking. For several seconds, nobody said anything. Sometimes silence is louder than testimony. I asked another question. Mr. Harrison, when exactly did you learn this was a memorial garden? He hesitated. The hesitation lasted only 2 seconds, but it was enough. I don't remember. I hear that answer frequently. People somehow remember profit projections from 5 years ago. They remember contract details. They remember permit numbers. But suddenly, memory disappears when accountability arrives. I leaned forward. You remembered enough to discuss it by email. His attorney objected, overruled. The answer stood. By now, the atmosphere inside the courtroom had completely changed. Earlier that morning, this had looked like a dispute between a wealthy company and a retired widow. Now it looked like something else. Now it looked like a powerful organization deciding that someone's memories were less important than its schedule. And juries understand that difference immediately. I asked Margaret one final question. If construction had been delayed long enough to protect the garden, would you have objected to the project itself? She shook her head. No. If they had spoken to you beforehand, no. If they had worked with you to relocate part of the garden, no. If they had shown respect, again she shook her head, no. The simplicity of her answers struck everyone in the room. She wasn't trying to stop progress. She wasn't seeking revenge. She wasn't demanding impossible concessions. She had wanted one thing, respect. That was all. An entire lawsuit existed because nobody bothered to provide it. The developer shifted uncomfortably in his chair. Then something happened I hadn't expected. Margaret reached into her purse. She removed a small envelope. The paper was yellowed with age, carefully folded, handled hundreds of times. She explained that her husband had written the note shortly before his death. The courtroom listened as she unfolded it. Her hands trembled, her voice trembled, but she continued. The note described the garden. It described the peace he found there. It described how much he hoped she would continue enjoying it after he was gone. There was nothing dramatic about the words that made them more powerful. Real love rarely sounds dramatic. It sounds ordinary. It sounds sincere. It sounds like people building a life together one day at a time. When she finished reading, nobody moved. Not the attorneys, not the spectators, not even the developer. The room felt different because everyone understood that what had been destroyed wasn't simply property. It was a connection, a reminder, a piece of someone's life. The law cannot restore memories. The law cannot bring back a husband. The law cannot recreate 46 years. But the law can acknowledge harm. And sometimes acknowledgement matters more than people realize. The defense spent another hour presenting arguments. Property boundaries, municipal permits, construction authority, technical compliance. They were well prepared, very professional, very polished. The problem was that every argument answered a question nobody was asking anymore. They kept explaining what they could do. The courtroom wanted to know why they did it. Eventually, closing statements arrived. The developer's attorney argued that emotional value should not override legal rights. A fair point. Legal rights matter. Then Margaret stood for her final statement. No lawyer, no script, no rehearsed performance, just honesty. She looked directly at the developer, not with hatred, not with anger, with disappointment, and somehow that felt worse. I know you can't bring it back, she said. I know flowers grow again. Her voice grew softer. But my husband won't plant them with me this time. Nobody interrupted. Nobody could, because there was nothing to argue against. Some truths are too simple to challenge. I retired to review the evidence. When I returned, the courtroom stood. I took my seat and opened the file one final time. The facts were clear. The timeline was clear. The responsibility was clear. Most importantly, the choices were clear. I began carefully. The issue before this court is not whether development should occur. I paused. The issue is whether people with power have an obligation to act responsibly when their decisions affect others. The room remained silent. The evidence demonstrates that the defendant's company was aware of the garden before construction began. I looked toward the developer. The evidence further demonstrates that concerns were raised internally. Another pause. And the evidence demonstrates those concerns were ignored. The developer stared forward, expressionless, or at least trying to be. The court finds that the damage was foreseeable, I continued. The court finds that reasonable alternatives existed. Another pause. The court finds that the plaintiff suffered substantial and meaningful loss. Margaret lowered her head. I could see tears forming. Not because of money, not because of victory, because someone finally listened. I awarded damages significantly higher than the company's initial settlement offer, much higher. But the financial judgment wasn't the most important part. The most important part came next. As part of the ruling, the company would fund restoration efforts under Margaret's direct supervision. Every replacement, every pathway, every memorial feature, every tree reasonably capable of restoration. Not because money fixes everything, because accountability requires action. For the first time all day, the developer spoke without consulting his attorney. Your Honor, with respect, it's only a garden. The words escaped before he could stop them. A terrible mistake. The courtroom froze. I looked at him carefully. Then I answered, No, Mr. Harrison. I let the silence settle. It's never only a garden. I pointed toward the photographs. To you, It was dirt. I pointed toward Margaret. To her, it was 46 years. Nobody said a word, because there was nothing left to say. The case was over. The ruling entered. The gavel came down. Most people assume that's where stories end. They are usually wrong. Several months later, I received a letter. Judges rarely hear what happens afterward. This time I did. The envelope came from Margaret. Inside were photographs, new flowers, restored pathways, fresh soil, new growth, life returning. But there was one photograph that stayed with me, a simple wooden bench beside the cherry tree. Attached to the bench was a small plaque. It contained her husband's name, and beneath it, a single sentence. Some things are worth protecting. I sat quietly for a long moment after reading those words, because they captured the entire case. Not gardens, not property, not money, principles. In every community, powerful people build things. Businesses expand, projects move forward, cities grow. That is part of progress. But progress without humanity eventually becomes destruction wearing a respectable suit. Success means very little if achieving it requires trampling people who cannot fight back. The developer left that courtroom with less money than he expected. Margaret left with something far more valuable: validation, dignity, the knowledge that her story mattered. And if there is one lesson worth remembering from that day, it is this: never assume something is insignificant simply because it appears small. A flower may seem small, a garden may seem small, a memory may seem small. But to the person who carries it, it may be everything. And when people forget that, courts exist to remind them.